Welcome to the Docketing Excellence webinar series.
Welcome to the Docketing Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is an accurate, efficient, and cost-effective US-based IP docketing and paralegal service provider. The SLW Institute is an educational group created by the Schwegman, Lundberg, and Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together docketing experts and managers from the Schwegman firm, Black Hills IP, and their respective clients and customers to help educate on key docketing challenges and issues and share best practices on how to overcome them. The Docketing Excellence webinar series is free. There are about 2 webinars per month through May of this year. To see a complete list of webinar topics and to register for future webinars, go to the Webinars tab of the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today is the 13th in the series. The topic today is Understanding Docketing for the Appeal Process in China, Korea, and Japan. We've allowed time for questions at the end of the webinar. Questions may be submitted using the Q&A button on the control bar on your screen. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation when we will go through them. Before we introduce our panelists, I want to invite anyone who is not already a member of the Docketing Excellence group on LinkedIn to join the community. This group is intended to be a community of IP docketing professionals and be a forum to allow people to ask questions and share tips and best practices. It's very easy to sign up. Just go to the website docketingexcellence.com. From there, you will be automatically redirected to the sign-up page for the LinkedIn group Docketing Excellence. After you're signed up, you'll be part of this community of IP docketing experts. The presenters today are myself, Jennifer Baumentry, and Christy Wheeler. I am Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center, which is now University of New Hampshire School of Law, for 5 years. Jennifer, let's start with you. Can you introduce yourself?
Good afternoon, everybody. This is Jennifer Baumentry. I'm a foreign filing paralegal with Schwegman, Lundberg, and Wissner, and I'm primarily responsible for the foreign filing applications for our clients. I've been with SLW for about 9 years now. Before I was with SLW, I worked as an in-house paralegal at Greco, and while I was at Greco, I was responsible for US PCT and foreign filings, US and foreign trademarks, and our IP budget. So it's been about 16 years now that I've been working in the IP field.
Christy, can you introduce yourself?
Yep. Hi, everybody. I'm Christy Wheeler. I'm a foreign filing paralegal at SLW. I've been in the IP field for 29 years, and 24 of those in the foreign aspect of it. I also co-supervise our foreign case managers and assist with docketing issues on the foreign side. Previously, I worked at a small boutique IP firm in Iowa for 10 years, and then at Merchant Gold for 6 years, and I've been at SLW for 12 years now.
Great. Well, Christy and Jennifer, thank you again for being with us for another webinar. Today we're talking about docketing appeals in Asian countries. The appeal docketing process in Asian countries is complicated by the differences in each country and the variations in terminology used by different foreign associates. The program will compare and contrast the appeal process in China, Korea, and Japan. So that'll be the 3 main segments of our program, with some brief comments at the end comparing and contrasting the process in those 3 countries. So again, we'll cover China, Korea, Japan, and then do a comparison at the end. I'll start with the Chinese appeal process. The main communications to Docket in the appeal process are the decision for rejection, the notification of reexamination, and the decision of reexamination, either being one revoking the original rejection or upholding the rejection. These are not necessarily the only documents that come through, but those are the main ones for docketing, and you want to make sure you have at least those critical items docketed correctly. So starting with that first one, docketing the Chinese decision of rejection. If you were on our program 2 weeks ago, you know that this is the equivalent to a U.S. final office action, and it typically follows a response to the first office action. The way you docket this is to docket a deadline to file a request for reexamination. That request for reexamination is what you can think of as being similar to filing a notice of appeal in a U.S. matter. So you docket a deadline to file a request for reexamination, which is due 3 months from the decision of rejection. It's very important to know that this is not an extendable deadline. So this is the way you get into an appeal, or you kick off an appeal from a docketing standpoint, is to have docketed that request for reexamination deadline. And that will be where the users of your docket determine, are they going to file an appeal or not? And if they do, that puts you into the appeal process. You may get then, after filing that, that request for reexamination, you may get a reexamination decision that revokes the final rejection. So basically saying the examiner's final rejection is wrong. If that is the case, the application at that point will be forwarded back to the original examiner from the Patent Review Board. The examiner at that point might issue a new office action and continue prosecution, or they might issue a notice of allowance. At this point, there really is nothing for you to docket. It's all in the examiner's hands, although, as we talked last week, it could be a good practice to docket a status check, just so you keep track of this and you don't lose track of the fact that this is in the appeal process. But things move pretty fast in the Chinese Patent Office, at least with respect to appeals, so don't docket that too far out. Maybe at most a 2 or 3 month status check if you decide to do that. Then the Patent Review Board, if the Patent Review Board instead decides to maintain the rejection that the examiner had given, then the Patent Review Board will issue a notice of reexamination. That term reexamination is, in China, is used to refer to what we would call the appeal process in the US. That notification of reexamination means that they're going to, as the appeal board, go through their review process for this particular appeal. If you receive that notification of reexamination document, then you need to docket a 1 month date to respond to that. And there is an extension available, a one-time extension of either 1 month or 2 months. But if you start out with a 1 month extension, that's all you get. Finally, the last major communication that you may receive to docket in the Chinese appeal process is a decision from the Patent Review Board, the decision of reexamination maintaining the examiner's decision of rejection. So if you receive this, this typically follows a response that's been filed after the notification of the reexamination communication. At this point, you have been unsuccessful on the appeal, and you have 2 options that you need to docket. One is either to file a divisional deadline, or to file a divisional for the application, and the other option is to file an appeal into the court system. So if you docket or to docket the divisional application filing deadline, that would be a 3-month response date from the receipt of the notification of the decision. To docket the appeal deadline, it's also a 3-month deadline from receipt of notification, but I need to make one correction from what we told you 2 weeks ago about this. 2 weeks ago, we said that the mailing period in China applies to both of these deadlines, the divisional deadline and the appeal to the court system. But that was not correct. The 15-day mailing period only applies to the divisional deadline. And as I think about this, that makes sense because that mailing period is an administrative rule set by the Chinese Patent Office. They can extend out their dates or modify their dates or determine how they calculate their dates with that 15-day mailing period. But the appeal to the court system, the appeal to the Intellectual Property Court of Beijing, is a different entity, and the rules that apply to when filings are due are going to be the court rules. And so that 15-day mailing period is a Patent Office procedural rule and does not apply to the filing of the appeal if you go that route. And this deadline is not extendable. That's also important to note. Now, very few people actually file an appeal to the court system in China. It's very expensive, and your chances of being successful are pretty slim. So more than likely, you're going to be going with that file the divisional deadline. And as we talk about China and Korea and Japan, just take note about what Christy and Jennifer tell you about divisional deadlines, because we'll talk about that again at the end of the program. But remember, in China, you can file a divisional after you get that final decision of rejection from the Patent Review Board. So now I'm going to turn it over to Jennifer to talk about the Korean appeal process.
So as you see on the screen here, there are about 3 main communications that you will be receiving from the Korean Patent Office at this stage. The first one will be a notice of a final rejection, a notice of a second final rejection, and then the last thing you would receive would be your appeal decision. The notice of the final rejection received from the Korean Patent Office is very similar to what you would see in the US as a final office action. To docket this, we have 3 items that you would docket. The request for reconsideration with amendments, you would docket a notice of appeal, and you would docket a divisional application. These items, the docketed deadlines for these 3 items are due 30 days from the receipt of the notification of the final rejection, and extensions of time are available once for up to 60 days. With the request for reconsideration with amendments, that would be one option. The appeal, if you choose to do the appeal, you do not amend, and you also have the opportunity there to file a divisional. So it's 2 different routes to go. Each route would contain your ability to file a divisional application, and they all have the same deadlines, and the extension for 60 days applies to both. After you've filed either the appeal or the request for reconsideration with amendments, the Korean Patent Office will come back to you with a communication, and it's going to be a decision on your request for reconsideration with amendments or your decision on your appeal. I've seen it come back, the communication be called Notice for Result of Reconsideration, and once you receive this document, it kind of ends the reconsideration phase of the appeal process. After you receive that communication, there's a couple of different possibilities of what it will say. You could have overcome the examiner's rejections, and then they'll issue a document called a preliminary rejection. So you kind of, you've gone through and you've handled all the rejections. Then you get kind of like a first office action all over again, because the examiner comes back and cites new prior art, or they have different rejections than the ones that were contained in your first final rejection. There's a possibility for a telephonic interview at this time too, and you'll also receive a communication that might give you an indication that you could file an additional appeal brief with a deadline to do that. After that, you'll receive a notice of a second final rejection from the Korean Patent Office. This is again like a final office action in the US, but in this instance, you're going to have far more limited options on how you can respond. No amendments will be able to be made at this point in time. The notice of the appeal, you're going to docket as a notice of appeal to the final rejection. It will be 30 days from the notification. This also is extendable one time with a 60-day extension period of time. And you will also have an opportunity within 4 to 6 weeks of filing an appeal brief. You'll get a communication that sets that deadline, a separate communication from KIPO that sets the deadline for the appeal brief due. At this point in time, you can also file a divisional, and this will be your last opportunity to get a divisional filed. The divisional will have the same deadline, 30 days from the notification of the second final rejection, and if you obtain an extension of time, you can also extend the deadline to file a divisional. This is extremely important. After this point of receipt of the second rejection, the second final rejection, this is your last opportunity to file a divisional. Any further communications from the Korean Patent Office, you'll be barred from filing a divisional application. So if you think there's a possibility that you're not going to prevail with the examiner, file the divisional application so you preserve your rights and you can continue prosecution if you get an unfavorable opinion. The last main communication you're going to get after you file the response to that second final rejection will be the appeal decision. In this case, the Korean Patent Office is going to maintain their rejection, and you will then have to docket the deadline to appeal to the patent court. This will be due 30 days from the appeal decision, and when it's received, it can be extended one time for 30 days only. And again, at this point, no divisional applications will be able to be filed. So that's why it's important to remember before you receive this final decision that you make the determination whether you're going to file that divisional application. At this point, you're barred from filing a divisional.
Okay, so that's a great point about the divisional, Jennifer. One of the differences then between China and Korea is after you get the decision of the Patent Review Board in China, you can still file a divisional, but here in Korea, you can no longer do that after you get the decision, and that is one key difference.
Yeah, so it's a big difference, especially if you have an application or an invention that you're trying to continue on in Korea. So file the precautionary divisional when you can, and if you get an unfavorable decision from the Korean Patent Office, you still can fall back on re-prosecuting the case again in the divisional application.
Good tip. Christy.
I just have a point on the China divisional.
Mm-hmm.
If your application is a divisional, you have no opportunity if that on your China divisional, even if you've gone through all of the appeal process.
Oh, good point. So it's just in the original Chinese filing.
Correct.
You can still file a divisional when you get to the end of the appeal process.
Right. The only way is if your parent is still pending,
Great.
which it probably would not be
right
by that time. So
good. I'm glad you clarified that. That's an excellent point. All right. Well, Christy, let's talk about the appeal process in Japan?
Okay. There's three major communications that you receive to start the appeals. It's the examiner's decision of final refusal, and it's also called the decision of rejection. There's a reexamination by the original examiner, the Rejectio examination. It's also called, also at that time, and it's the original examiner can accept it or reject the application again, and then a review by the Board of Appeals, and that's an acceptance or rejection. You can go, this slide relates to the original examiner's decision of rejection. It's also called the decision of final refusal, and it's received from the examiner, and it's like the final office action in the US. How to docket it is 3 things, going for 4 months on most of our applications. However, there is a 3-month deadline that we'll discuss on the next slide. And you're going to notice docket a notice of appeal to the Board of Appeals, the arguments and voluntary amendments, and then a precautionary divisional application or a divisional application. And there are no extensions available. Now, I have received an agent letter sending me what they called was a notice of rejection, and they were going to submit English translation later. So I received the English translation 3 weeks later, and they said, oh, this is final, which made it, instead of just an office action, then we needed to go into the appeal process. So the agents are not always clear on using the terminology, and so you just kind of need to look at maybe the extensions of time, because with the appeal process there's no extensions. So if they have some extension of time on there, you might believe them to be an office action. So
I would always say, if you're in doubt, email the agent right away and ask them, is this a rejection or is this a decision of final refusal, just to clarify for yourself if there are any questions, rather than waiting for them to provide you with the translation that then tells you it's a final rejection.
Anyway, you can do the notice of appeal. If you're going to appeal the application, you should always file a precautionary divisional application. That could use just an omnibus claim, and we'll explain why later. Or if you do not want to file an appeal, you can file just your regular divisional application. And sometimes the decision from the client doesn't come until later. I mean, at the very last minute. You don't have to provide claims at that time. You can just say, we're going to file a divisional application. The request for examination deadline on that divisional application is 30 days from filing. So you would have 30 days to provide new claims for your divisional application. And that's if you do not file an appeal. When you do file an appeal, you'll want to include arguments and voluntary amendments. And as discussed about the 3 months and 4 months, most of our applications will have the 4 month docketed date, because those are for overseas applicants. That's non-Japanese. The domestic applicant, if you look at the laws, they'll talk about domestic applicants. Well, for us, we feel like we're domestic, but not to Japanese. So those, and you might have a Japanese client that you're representing. So you would need to docket that at 3 months. But again, the types of actions that you're going to docket are not any different, whether it's 3 or 4 months.
Interesting, but there's a different timeline depending on whether it's applicant in Japan or outside of Japan.
Correct. So, okay, so when you file your appeal, and there are amendments in the case, or prior to the appeal board reviewing it, they're going to send it back to the original examiner. And this is called a Zenchi examination. And there are no docket deadlines to make note of. And many times your agent will not even advise you of that. But we have had questions on what is this Zenchi examination, and that is when the appeal has been processed and before the board reviews, they want to go back to the original examiner who knows the application for his review. And the original examiner at that review may allow the application, or they may maintain the rejection. So if it is allowed, then you're going to receive the notice of allowance where you need to docket your issue fees and annuities. That's the first 3 years of annuities, 1 to 3. And then point out that a divisional application can also be filed at this point if you haven't already filed a precautionary divisional. And then if rejected, the application then goes back to the Board of Appeals to decide on the appeal process. Now, it's very important to understand that this taking it back to the original examiner does not mean that your appeal was successful. Doesn't mean that at all. And it's just part of the process. When there's a new arguments or amendments, the original examiner has an opportunity to will consider it one more time. And then if the application is allowed, of course, the issue fees are due, which are the first 3 annuity payments. So you may get a document at this time also stating what the 3 trial examiners' names are. You know, it's just a document. It doesn't, again, it depends on your agent if they're going to share that information with you.
And I just want to point out, you said in this slide that the divisional application can be filed at this point. And at this point, you're talking about during the Zenchi examination, when the original examiner is considering something, reconsidering the case, and they decide to allow it. Right. It's not based on a decision to allow by the Board of Appeals. And that's a distinction I think you're going to point out for us, right?
Correct.
Okay.
So the Zenchi examination has been done, and they did not allow it. They upheld the examiner's rejection. So you may issue, or the appeal board may issue its own office action, and it's at the discretion of the appeal board. So they may feel like they're making some progress, but they want a little bit more from you. So they'll, you know, and that's a 3-month deadline for a response. Then it may look like an ordinary non-final office action. So you really kind of be aware of where your application is in the process. So if you look at the file history and you see, well, this is on appeal, what are we getting an office action for? That's from the trial board. And sometimes they're not clear on where that office action is coming from. So you'll get an office action, or may get an office action. That's up to them. And then once that office action is responded to, or if it just clears from the original arguments and amendments, the appeal board may just issue its decision on appeal. There's 2 types of decision. Of course, the decision to grant, and then the decision of rejection. Now, even if you receive a decision to grant, this is one where you cannot file a divisional application anymore. So that is why back at your filing of the appeal, why you filed a appeal. Precautionary divisional, yes. And that's because the divisional applications can only be filed in response to an office action, and the Board of Appeals is not
their decision's not an office action.
So no divisions can be filed at that point. And if they do a decision of rejection, the deadline is 120 days. And there's 3 items to docket on that decision of rejection by the appeal board. It's 120 days for filing the lawsuit to the Japanese Intellectual Property High Court. You're going to need a power of attorney from the client or applicant and a notarized copy of their corporate certificate. And again, a divisional cannot be filed at that point. The likelihood of overturning the decision of rejection by an appeal board is very, very low. However, the success rate for an appeal to the Board of Appeals is about 50%. So it's worth doing, and the cost is not that great.
Okay.
So you might as well try.
Okay. Good. Thank you, Christy. We've just talked about things that are very, very specific procedural steps for a very limited part of the docketing process in China, Korea, and Japan. It's specific to the appeal process. Now I want to step back and talk about what, as docketers, those of you who are listening as docketers, should take away from this program. First of all, at the high level, there are some similarities between these 3 countries. For example, all 3 countries have an appeal board within the patent office, and that appeal board will review an examiner's rejection, a final rejection. So somebody other than the examiner, there's an opportunity to have somebody other than the examiner in each of these countries review an examiner's rejection, and that's through the appeal process that we just walked through. Also, common across all 3 of these countries is the fact that if you're unsuccessful with your appeal, there is a mechanism that allows you to take an appeal to the appropriate court to have the appeal board's decision further reviewed. Now, like Christy said, that's not generally something that's typically successful in Japan, and it's also something that's not typically successful in China. I don't know about Korea, but in any case, those aren't common options, but the option is there when you have a very important case, and that's the route that you want to go. So there's a common across the 3 countries that we just talked about. There are, however, some differences that I want to make sure everybody takes away from this program that are particularly important to docketers. And one of those is the differences in the deadline to file a divisional application. This is really, really important because, as we just heard from Jennifer and Christy, in Korea and Japan, the time is limited in which you can file a divisional application, and you can't assume that you can wait all the way up until the end after you get your decision from the appeal board, and if it's negative, then file a divisional. You can't do that in Korea and Japan, so you have to file that divisional much earlier in the process. And because of that, as a docketer, it's very important that you have a docket deadline entry specific for filing a divisional, so that you have that triggering whoever's making that decision, and they don't miss that opportunity, because you don't want them to get to the end of the process, have a negative decision on their appeal, and then realize that it's too late to file a divisional because there was nothing on the docket earlier in the process to trigger them to do that. That would be very bad. They'd be out of luck. You can't fix that. Another thing that's different, and I think is important as a takeaway for docketers, is the terminology and timelines for filing a notice of appeal. So even if you work for an organization that never actually files an appeal in any of these 3 countries. As long as you're working for an organization that has applications being prosecuted in each of these 3 countries, you are at least going to be docketing the deadline to file the notice of appeal. So it's important that everybody, regardless of your likelihood of actually getting into an appeal, knows when and how to docket the deadline to file the notice of appeal. So let's just look at that real quickly, because I want to make sure everybody on this program understands these differences. So when do you docket a notice of appeal? In China, you docket that after you receive the document called a decision of rejection. That decision of rejection, like I said, is like your final office action, but the document itself is called a decision of rejection. And the deadline that you need to docket is a 3-month deadline from that decision of rejection. And it's a 3-month deadline to file what's called the request for reexamination. So if you're dealing with China, that's how you docket what we would call the notice of appeal deadline. Korea has a much shorter timeline, and it's tricky because there's 2 different documents that could trigger a notice of appeal. You can file a notice of appeal following either the examiner's the final examiner's rejection, or if you go through the reconsideration process, you get a second final examiner's rejection, and after that second final examiner's rejection, you also have the opportunity to file a notice of appeal. So there's 2 different points in the process, 2 different documents that you would see as a docketer that should trigger you to have a docket deadline for filing a notice of appeal. And that deadline is a shorter deadline. It's actually quite quick. It's a 30-day deadline that you're docketing. Then in Japan, the document that's going to trigger the filing of a notice of the docketing of a notice of appeal is called the examiner's decision of rejection. Sometimes it might be called the examiner's decision of final refusal. But when you get that examiner's decision of rejection, you as a doctor should then be docketing a notice of appeal deadline that is generally 4 months, unless you have a applicant that's a Japanese applicant. So it depends on the location of your applicant. So again, although each country allows for an appeal after a final rejection by the examiner in the same way that the U.S. allows for an appeal after a final rejection by the examiner, there's differences in terminology and timelines. And even if your organization never actually files an appeal, what we're looking at on this slide is important as docketers to understand, just so you have those deadlines docketed in case you might file a notice of appeal. So today we've talked about the docketing appeals in China, Korea, and Japan. It's a very specific topic. If anybody has questions, we will allow for questions at this point. So remember, you can submit questions through the Q&A button on the control bar on your screen. And if you have questions regarding Black Hills IP's services or processes, please contact our Vice President of Sales, Jim Brophy. His contact information is on the slide that you're looking at. We have one question in the queue, that is, by listening to this appeal process, we cannot therefore create an automated continuation divisional deadline in China, Korea, and Japan, because we have to identify on what stage the appeal process is. And this is a question just asking for confirmation. So Christy and Jennifer, I'm going to let you take a minute to read that and confirm that, see if you agree with what this viewer is saying.
In Japan, the original decision of rejection can be, with the notice of appeal, a divisional should be docketed at that time.
I think I agree with the person asking the question. You can't automate that divisional deadline. I think that's what the questioner is getting at. You can't automate that deadline in a divisional for Japan or Korea or even China. You have to wait and identify what stage you are in the process in order to docket for that divisional deadline. So I agree with the questioner on that.
And at that point, determine if procedurally a divisional is permissible, and then if so, docket it at that point, right?
Right, because if you've gotten in Korea, if you've gotten to that second final rejection, you have the ability to file a divisional, but then once you get that appeal, the final appeal decision, your divisional deadline is barred. So your system should not automatically be docketing for a divisional at that point because you can't file one.
Right. So no substitute for understanding where you are at in the process. And also, even though you have your foreign agents in most cases that you're working with, you really should understand what the process is so that you can be double checking that and be aware of how these deadlines should be docketed, particularly for divisionals, because you don't want to get into a spot where it's too late. That is one of the key takeaways I want people to have from this program.
Or even putting a divisional and asking the client if you want a divisional and the opportunity's not there.
Oh my God, that would be embarrassing.
Yeah.
Yes, that would be very bad. Okay, so okay, we got questions rolling in. Let's go to this second one. So the second one, is there an indication on the Japanese rejections that there are Japanese applicants so that it is clear that an earlier response deadline, the 3-month deadline in our example, should be used as opposed to the 4-month deadline? That's a great question. I've never worked on a case that had a Japanese applicant. Have either of you guys?
I have, but your agent is going to tell you by their date. You know, this is a 3-month response period, and also it should be your client or you know, a client of yours that you can check on their residency.
Okay, so if first of all, if you're expecting it to be a 4-month deadline because you know it's a 4-month deadline and the agent tells you 3 months, that's a clue, right? That it's because you have a Japanese applicant. And in most instances, if your organization filed the original application and then the Chinese application is claiming priority to it, you're probably close enough to the client that you know whether they're Japanese applicant or not. That's what you're saying, right?
Correct. You know, it could be licensed to a different, or, you know, assigned to a different company, but that's basically.
So with respect to, is there something on the actual Japanese rejection, not that we're aware of, it's either your knowledge of the client or the deadline in the agent's letter that they send to you, but the Japanese Patent Office, as far as we're aware at least, isn't making a determination of whether it's a Japanese applicant or not, at least that they note on the documents.
Right.
Okay. Great question. All right. Here's the third question. For Korea, for the first final rejection, you said 30 days from the receipt is the deadline. And for the second final rejection from the notice, so I think the focus on this question is it 30 days from the receipt of the rejection or 30 days from the notification of the rejection? Can you confirm that I understood that correctly? That the deadline for the first rejection is from the receipt and the second rejection is from the mailing date of the notice? That might have just been me not being careful on the slides.
I don't think that we made a very clear distinction from the receipt versus the mail date of the notices.
Yeah.
I think that in both, so let's say this, I've worked in IP for 16 years and Schwegman for 9 years, and in 9 years with Schwegman, I've received a grand total of 4 of these.
Holy cow.
4 of these cases in a 9-year span. I believe that the 30-day deadline comes from the mailing date of the notification from Kaipo, but I'm going to have to clarify that, and the Korean associate will put your 30-day deadline in their reporting letter. But from the cases that I reviewed when I was preparing for this, the deadline is set from the mailing date of the rejection notices, both the first final rejection and the second final rejection notice.
Well, Cheryl, that was a great question, and I'm glad you picked up on that subtlety, and that was unintentional. I was the one that did those slides, and it was unintentional on my part, so I'm glad you asked that question. Last question is, can I get a copy of the slides? The copy of the slides will be available on the Black Hills IP website, along with an audio recording of today's program. So let me go, hang on. Yeah, so yeah, we'll post the slides and the audio recording on our website under the webinars tab. The website is blackhillsip.com. It will take us a day or so, maybe a couple days to get those up and posted, but if you check back next week, for sure those will be up and available. So our next webinar is on best practices for docketing the validation process in the EP. That program is on April 12th at 1 p.m. Central Time. Again, to register for this webinar, go to the Black Hills IP website. And thank you very much for participating today. We hope you will join us for this upcoming webinar on EP validations and other webinars in our series, and that you join us in our LinkedIn Docketing Excellence group. Thank you for joining today.